The member for Warringah.
I welcome the Australian Human Rights Commission Amendment Cost Protection Bill 2023. It aims to address Recommendation 25 of the Respect at Work report and does so with some changes, which I do welcome, because when I had looked at that recommendation in Respect at Work, in my former life as a barrister, it did sit a little uneasily with me where the recommendation went in terms of changing from the usual costs orders, and so I do welcome the approach the government has taken. So the recommendation from the Respect at Work report was to insert a cost provision into the Australian Human Rights Commission Act to provide that a party to proceedings may only be ordered to pay the other party's costs in limited circumstances. And so I agree with that in principle. The issue of cost protection is one which has exercised my mind for some time now. I spoke about this issue last year when the Respect at Work bill was introduced, and I was pleased to support that bill, which was also included cost neutrality provisions which provided much-needed security to employees bringing a complaint for sexual harassment. Having come from the family court system, the family law system, with the norm being cost neutrality, it's an important aspect, but can sometimes be difficult depending on how parties conduct themselves in proceedings. So I'm pleased to see the government continues to seek methods for giving much-needed security and safety to applicants who may otherwise be reluctant to bring claims for fear of being left when a burden of oppressive costs where their claims are ultimately not successful, because it is expensive to bring on litigation, and if unsuccessful, a claimant would, in the ordinary course, face bankruptcy and just complete ruin for having had the courage to bring on their claim. The intention behind the changes this bill puts forward is to remove the risk to victims and survivors that by seeking redress they may open themselves up to the risk of having to pay the other party's costs should they be unsuccessful in their claim. So it doesn't take much to the imagination to see how the risk of having to pay the legal costs of your perceived attacker or worse, and for example an organisation, which could be a large organisation with very deep pockets, would deter a vulnerable person from making a claim of sexual harassment or other form of discrimination in their workplace. The many and varied manifestations of sexual harassment and other forms of discrimination have fortunately become more widely discussed and reported on in recent times, particularly since the emergence of the Me Too movement. The previously seriously underreported and debilitating effects of such behaviour has now entered the public consciousness to a degree that enables informed public dialogue and understanding, and this must continue. Disproportionately, victims are women or people forming part of the LGBTQI+ community or from minority ethnic groups. Their experience of society, and in particular of the workforce, is such that they are significantly more likely to feel marginalised, disempowered, or not visible to or recognised or understood by others, making it all the more difficult to bring on allegations and claims. Although it's not always the case, it is far more likely, therefore, that they perceive the justice system as being unable to understand the nuances of their very personal and traumatic circumstances which they have experienced and which have led to the physical, financial and psychological trauma which they may have suffered. And I've not even started to talk about the unpredictable influence of the often self-interested, headline-seeking media. And we have seen that to its worst in recent times. So how does this work in practice right now? Potential claimants will be told by their lawyer that while the judge always has a discretion to make a customised legal cost order to reflect what the judge considers to be fair in all circumstances, by far the most common situation is that costs will follow the event, and in fact it's the default position, which means that when the applicant makes out their claim and wins, the respondent will pay the applicant's legal costs. Conversely, however, if the applicant fails to make out their case against the respondent, the applicant could be ordered to pay the respondent's legal costs. Now, when an applicant is taking on, for example, a claim against a large corporation in relation to a workplace issue and discrimination, that is incredibly daunting and can lead to bankruptcy and complete ruin. There are many reasons why this might be a logical starting position in commercial disputes, and it is the norm that if you bring on a case and you fail to make out the case, that cost provision should flow and should follow that course. However, for a psychologically affected and vulnerable victim or survivor of sexual harassment or other discriminatory behaviour in their workplace, they who are already steeling themselves against an extended period of public scrutiny and testing through the adversarial court system, and we certainly have seen this with recent allegations and events in this place, this may be one bridge too far, leading them to abandon the attempt to seek legal redress. And that means we all pay a price because the system and workplaces do not become safer and better. So it was recognised by the Respect at Work report, which recommended introducing a cost protection provision. This provision, proposed by the government, however, differs in a few aspects, and I must say I do support the difference the government has introduced. Under this bill, an applicant can only be ordered to pay the respondent's costs if the respondent is successful in the proceedings, so the applicant has failed to make out their case. 2, they don't have substantial, the respondent doesn't have substantial financial resources compared to the applicant. So in my mind, this really covers where you have a smaller workplace or you have an individual where you don't have an incredible difference in means between the two parties to proceedings. Obviously, for smaller businesses, if they are subject to a discrimination or a sexual harassment claim in their workplace, that can also be debilitating for a small business. So it's incredibly important that we find a fair result in relation to this, a system that encourages and facilitates victims from bringing forward their complaint, but not a system that will disproportionately impact respondents as well. And thirdly, that the respondent doesn't have a significant power advantage over the applicant. So that is clear when we're talking businesses and workplaces between an individual applicant versus a workplace with much more resources available to them. I think that these criteria are sensible and probably fairly easy to establish before the court, whether the respondent was successful in the proceedings and what the respondent's financial situation is. Establishing the third, I'm concerned, might be difficult in terms of whether or not there's a significant power advantage, and that won't be an easy task. And so I think it will be important to monitor how this legislation progresses in practice and review, if necessary, to ensure that it is striking the right balance in assisting victims being able to bring forward without that fear of costs, but also that we don't have a detrimental and unfair system resulting. So I thank the government. I welcome this bill with these amendments and the implementation of the Respect at Work recommendations. It's incredibly important that we continue to progress healthy and respectful workplaces and safety. The most important thing, I believe, is as members in this place, we have a duty to keep emphasising. As a member of the Parliamentary Leadership Task Force, tasked to implement the Set the Standards report recommendations in relation to the Commonwealth and parliamentary workplaces, I certainly welcome these provisions and urge all members to continue engaging with PWSS and the resources available to us as employers to ensure safe workplaces. Thank you.